Welcome back, dear students. Today we are going to take up another lecture relating to drafting of revision petition and review petition. Here are few references before you, which we have discussed earlier also. So you can select any one of these books for learning how to draft revision and review petitions. Dear students, we have already learned the drafting of memorandum of first appeal, and we have also understood that appeals are filed under Order 41 CPC, that is first appeal against the decree, and second appeal against the decree can be filed under Order 42 of CPC. The first appeal lies on question of facts as well as law, and second appeal lies only when substantial question of law formulated by the court is involved, and appeal from orders, that means other than decrees which are passed during the pendency of a suit. Such appeals are filed under Order 43 of CPC. List of appellate orders is given in Order 43 of CPC as to what orders are appealable and what not. Then coming to the present lecture of drafting of revision, dear students, you should know that revision to be filed by the aggrieved party, or it can be undertaken suo motu by the revisional court, and revisional court can call the file of the lower court for revising the order of the lower court. This cannot be done while sitting as an appeal. Appellate court has no power to call for the record of the lower court and start hearing the appeal. But revisional courts do have such powers. Rather, it is the duty of the revisional courts to rectify the mistakes of the lower courts suo motu also. So revision can be filed by the aggrieved party, or court can suo motu take cognizance of the matter and start hearing the revision petition. Now the question is how revisional court will come to know that lower court has committed some error. Generally, I have seen at the court compound when I was posted as district and sessions judge in various districts, the advocates from bar association, they used to inform the district judge that such and such officer, such and such magistrate is passing orders against the law. They do not want to file revision directly, but they bring it to the notice of district and sessions judge. And then as district and session judge, I used to call the record of the lower court by drawing an order sheet, suo motu. And then when file of the lower court is received with the revisional court, notices are issued to both the parties and the revision is heard. But dear students, there are certain grounds of revision also. The first condition is that revision is applicable if no appeal lies there. If there is a right of appeal, then party has to go in appeal. But if there is no appeal, the stage of appeal has not come, then party has a right to file a revision petition. There are mainly three grounds of revision. Why I am telling you this theory, the reason is that if there are three grounds of revision, you are supposed to draft one or more of these grounds in your revision petition. So the first ground is that the lower court has exercised a jurisdiction not vested in it by law. Suppose a civil judge junior division has jurisdiction to decide cases up to 5 lakh valuation in UP, and he has decided he is going to decide a case worth rupees 1 crore valuation and has passed certain orders. So you can say that lower court has exercised a jurisdiction which was not vested in him by law. Because law says that you cannot hear a case whose valuation is beyond 5 lakh rupees. Second ground is the reverse of it, that the learned trial court has failed to exercise jurisdiction vested in it by law. Jurisdiction was there, but the lower court has failed to exercise jurisdiction. Again, the revision will lie against that particular order. And the third ground is that the lower court has acted in the exercise of its jurisdiction illegally or with material irregularity. Jurisdiction was there, jurisdiction was exercised, but with illegality or with material irregularity. So these are the three grounds of revision. You are supposed to draft one or more of these grounds in your drafting of revision petition, but the first and foremost condition is that revision petition will lie if no appeal lies. If there is a right of appeal, then you will have to file memorandum of appeal. Then, dear students, one more rider for you, that filing of revision does not operate as stay unless the stay order is expressly granted by the revisional court. In UP, High Court as well as district and session judges are authorized to hear and decide revision petitions. High courts have unlimited jurisdiction, and district and session judges can hear revisions against those orders whose original valuation in the suit was 5 lakh rupees. So districts and sessions judge and high courts in UP both are competent to entertain revision petition, or they can suo moto start the hearing of revision. Now, dear students, what is the test of maintainability of revision? You should know it before you start drafting. The test is, it is very simple. Where the impugned order means order which you are going to challenge in the revision. Where the impugned order, if it had been made in favor of the revisionist, would have finally disposed of the suit or proceeding. You will have to reverse the order in your favor and see whether reversal finally disposes the suit or proceedings or not. So, say for example, the court has decided an issue of jurisdiction, that the court has jurisdiction to decide this case. Now you negate it, you reverse it, that the court has no jurisdiction to decide this particular case. Once the court has no jurisdiction, then matter terminates in your favor, because it was your objection as defendant that court has no jurisdiction, and court has passed an order, no, we have jurisdiction. So this order passed by the lower court that they have jurisdiction to decide a particular case is revisable, because if this order is reversed, reversal means that court has no jurisdiction, then it terminates the proceedings in favor of defendant. Similarly, if a criminal court has passed a summoning order against me that I have committed murder, I want to file revision against this order. Now negate it and reverse it. Reversal means that no summoning order. I have not committed murder. I cannot be summoned. So all proceedings have terminated in my favor. Hence, the original order of summoning of the accused is revisable according to law. Now, with this background knowledge in mind, we will start drafting, actual drafting of a revision petition. First of all, you will have to select the name of the court, and name of the court is in the High Court of Delhi at New Delhi. Revision petition number dash dash of 2017. Here you know year of filing revision, but revision petition number will be allotted to you by the court. And our revisionists are three: A, son of B, resident of 52 Lajpat Nagar, New Delhi; C, son of B, and D, son of B, with the same address, and their parentage shows that all the three revisionists are son of B, that means they are real owners. Versus who is the respondent? X, son of Y, resident of 906 Designers Park, Sector 62 Noida, Gautam Buddha Nagar, UP is our revisionist. Now revision against, this is the center heading, that revision against order dated so and so passed by the Court of Civil Judge Junior Division New Delhi in suit number 27 of 2016. Original suit which is pending before the Court of Civil Judge Junior Division, its number is 27 of 2016. This is all hypothetical. Salutation line will be, the revisionist most respectfully submit as under. Number 1, that Shri B, father of revisionists, expired on 1/1/2016, leaving behind the revisionists as his sons or legal representatives. Para 2, that in the month of February 2016, the respondent X instituted 5 suits against the revisionists on the allegation that B had executed 5 promissory notes in his favor during the year 2014. All these suits are being tried in different subordinate courts at Delhi under Order 37 of CPC. The certified copies of the 5 plaints are enclosed herewith as Annexure 1, 2, 3, 4 and 5. That the summons for judgments of all the 5 cases were served upon the revisionists. Thereafter, the revisionists moved an application under Order 37 Rule 3 and Section 151 CPC before the trial court. The copies of the said application and accompanied affidavits are filed herewith as Annexure 6th and 7th with this petition. Para 4, that the trial court, after hearing the arguments of the counsel for the parties, announced the impugned order and granted leave to contest to the petitioners, but subject to their furnishing a bank guarantee of rupees 7,500 for the suit amount and estimated cost within a period of 1 month from the date of the impugned order. Dear students, you know that in the last lecture we had studied the working of Order 37 of CPC, where summary suits are filed. So here in this case, the leave to defend was granted, but there was a condition that a bank guarantee of 7,500 rupees is to be given. Para 5. The respondent submit a reply to these applications, and the true copy of the said application is filed herewith as Annexure 7. The grounds on which leave to defend was prayed by the revisionists are briefly stated as follows. Number 1, a suit under Order 37 Rule 2 of CPC can be instituted or tried only against executant of the document and not against his legal representative. This is the first ground, that suit under Order 37 can be instituted or tried only against executant of the document and not against his legal representatives. B, second ground, the fact that respondent has filed 5 different suits on the basis of 5 promissory notes shows that X was a money lender, and since the plaintiffs were silent in this respect, all the 5 suits were barred under provisions of Punjab Registration of Money Lenders Act 1938. This is the second ground of revision, and this law is applicable to Union Territory of New Delhi also, and X has not complied with provisions of the said Act and his claims are covered in the definition of loan and interest as defined in the said act. Third ground is that in the plaint, a sum of rupees 150 has been claimed as costs of legal notice, besides principal amount and interest on the basis of alleged promissory note, whereas a suit under Order 37 Rule 1 and 2 can be filed only with respect to amount due on the basis of promissory notes, and any relief falling outside the ambit of promissory note cannot be claimed in a suit under Order 37 of CPC. Fourth ground, D. The copies of the documents which have been made the basis of the suit were not supplied to the revisionists along with the plaint. Fifth ground, E. The alleged promissory note or the receipt does not bear the signature of the father of the revisionist, and his signatures have been forged and fabricated. This is my fifth ground, that the promissory notes are forged and it does not bear the signature of their father. Sixth ground, F, that the said promissory notes were not properly stamped or signed. Next ground, G, that suit cannot be tried under Order 37 CPC and it should be directed as such, or in the alternative, unconditional leave to contest the suit may be granted to them. It is therefore most respectfully submitted that the impugned order of the learned trial court suffers from material irregularity and is perverse, wrong in law, and liable to be reversed and set aside by this honorable court on the following grounds, amongst others. Now, the grounds of revision are: number one, that the lower court has exercised a jurisdiction not vested in it by law. Second ground, that the learned trial court has failed to exercise jurisdiction vested in it by law. And third, that the lower court has acted in the exercise of its jurisdiction illegally or with material irregularity. You see, my dear students, all those three grounds have come up in your drafting. That is the reason I tell you the theory behind the drafting of everything. So these are the main three grounds of this revision. And fourth one is that the trial court has ignored the ratio decidendi of various verdicts of the Supreme Court on the issue before it. And fifth one is that Supreme Court's judicial precedent commencing from 1958 Santosh Kumar's case to 1965 Milky Ram's case have laid down that whenever the defense raises a tribal issue, leave must be given unconditionally. Otherwise, leave may be illusory. Para 6. That if trial court was of the opinion that defense raised was frivolous or false, it should have refused leave to defend altogether. The lower court may, in its discretion, could have imposed conditions as to time or mode of trial, but not as to payment into court or furnishing security according to ratio of the case laws. And 7, that the impugned order is perverse, wrong in law, and upon facts of the case. And 8th one is that the revisionists or defendants are admittedly not the executants of the alleged promissory notes. Why? Because their father had executed it. Even the said notes in question were not executed by their deceased father, and the said notes do not contain his signatures. In case the plaintiff respondent is able to prove that said promissory notes are genuine and were executed by their deceased father, then also under section 52 of CPC, the plaintiff would at the most be entitled to a decree executable to the extent of the property of the deceased remaining in their possession after discharging his debts and liabilities. Yes, this is another ground that I am liable to pay the debts of my father only to the extent I have inherited property from him. And 9th, that by the impugned order, the London lower court has granted leave to defend on furnishing a bank guarantee. And a bank cannot be obtained only by depositing the entire amount in the bank. If the petitioner fails to comply with this condition, the suit of the plaintiff will stand decreed against them, because the prayer in the plaint is that the suit may be decreed with cost and future interest against the defendants. And para 10, that the impugned order contravenes section 52 of CPC. And if the impugned order is allowed to stand, lower court will grant such a relief to the plaintiff which the plaintiff would not be entitled in the event of suit being tried in ordinary manner or revisionists being allowed to defend the suit. So the order is perverse. Para 11, that the trial court overlooked the fact that in the plaint, a sum of rupees 150 as cost of the notice was also claimed, and no such amount can be claimed under Order 37 of CPC, where in event of leave being refused, the suit will stand decreed without any evidence or trial, and at that time, the trial court will be debarred from disallowing this amount of rupees 150 as cost of the notice. So this order passed by the lower court is patently wrong. So the prayer is to be drafted like this. It is therefore most respectfully prayed that this revision may kindly be allowed and impugned order may kindly be set aside and reversed. An unconditional leave to defend may be granted to the revisionist along with cost of this revision. After the prayer clause, the revisionists, all the three revisionists will put their signatures at the end of this revision petition. And since this revision petition is drafted by ABC advocate, you will write down through ABC advocate, and ABC advocate will also put his signatures on this revision petition. Then, dear students, you are supposed to draft the place of drafting. Place of drafting is New Delhi. Date of filing this revision petition in the court is 1st March 2017. Please note that a duly filled up opening form is to be attached on the top of the revision petition, and same format can be used for drafting first appeal, where you will replace the word memo of appeal instead of revision petition. So dear students, this is how we have learned the drafting of a revision petition, incorporating all the three grounds on the basis of which a revision can be filed. Moving further, we will now learn how to draft a review petition under CPC. You will have to see Order 47 and Section 114 of the CPC, which gives you the grounds of a review petition. You see, any aggrieved party may apply for review of a judgment or order to the court which passed the decree or order. So the first and foremost condition is that review application has to be drafted for that court who had passed the order against which you are going to file review, or before the same court who has passed the judgment against you. But there are three conditions before you can apply for a review. The first condition is that if appeal from that particular order is allowed, but no appeal is preferred. See, the order is appealable according to Order 43. But you have filed no appeal, then you can go for appeal. Second condition is that if no appeal is allowed from the order is non-appealable, तब क्या करेंगे? तब तो review ही file करेंगे. And third, that by a decision on a reference from the court of small causes. Court of small causes has referred this matter to a higher bench, higher court, and higher court has decision given on reference from the court of small causes. So that decision, against that decision, you can file a review petition. But review, dear students, only once it is allowed. review of review is not allowed. And this review is allowed only in civil cases. No review in criminal law. Once you have passed the sentence or you have issued order of NBW against an accused, you cannot review your order. You can pass fresh order, but you cannot review your own order under CRPC. But CPC permits you to review your own order under the conditions mentioned in Order 47 and Section 114 of CPC. Now, what will be the grounds of review? You must know before you start actual drafting of a review petition. Number one, first ground available to you is discovery of new and important matter or evidence which was not within the knowledge of the applicant or could not be produced by him when the decree was passed. So the first ground is that after the decree or after the order, I have discovered a new and important matter which was not in my knowledge. Suppose a particular deed which was kept by my father in bank locker. It was not in my knowledge when the order was passed against me. But after death of my father, when that locker was opened, I found a particular document which is relevant for the case. So now I am in a position to file that deed before the court again, along with my review application. Second ground is the order was made on account of some mistake or error apparent on the face of record. This is a ground of review that if you read the order, it contains an error which is apparent on the face of record. And the third ground is any other sufficient reason. But care has to be taken that reversal of ratio of a case by superior court after the judgment shall not be a ground of review. This means that when the order was passed against me by the trial court, the ratio decidendi of a Supreme Court, say, was X. And after the judgment of the trial court, a new judgment is pronounced by Supreme Court, changing the ratio decidendi from X to Y. That suits to you in your case, but this shall not be a ground of review. If the higher court have reversed their ratio after the judgment of the trial court, then reversal of ratio by the superior court shall not be a ground for review of the decision of the trial court. And dear students, review is to be heard by the same judge or same court as far as possible. If the judge has been transferred to another district, new one has joined, then new incumbent will hear your review petition. But the court should be same as far as possible. If the court has been abolished, then somebody is in charge of that court also. So the thumb rule is that review is to be heard by the same judge and by the same court. And decision of the majority will prevail. If the judges are equally divided, the review shall be rejected. This position will come in the High Court or Supreme Court, not at the trial court, because in the trial court, all judges are sitting individually. But in the High Court, if there is a 3 judges bench and you have applied review before them, then decision of majority will prevail. If the matter is heard by division bench and they are equally divided, one judge says review should be allowed, another judge says no, it should be rejected, then legal position is that if judges are equally divided, review shall be rejected. So dear students, with this background knowledge in the mind, now we will start drafting an actual review petition or review application. So first of all, the name of the court. Name of the court has to be the same who passed the order against him. So in this illustration, the name of the court is in the Court of Civil Judge Senior Division Noida, District Gautam Buddha Nagar, UP. Civil suit number 23 of 2017. You know the suit number because an order has been passed against you. Name of the parties, plaintiff and defendant will remain same as they were in the original plaint in which the judgment or order has been passed. You cannot change the name of the parties while drafting review application. The name of the parties has to be copied from plaint, copy pasted here. So our plaintiff in this review application is A son of B, aged about 40 years, resident of flat number 918, Pavilion Court 10, JP Greens, Wish Town, Sector 128, Noida, Gautam Buddha Nagar, UP is our plaintiff. And versus this case was filed against X son of Y, aged about 45 years, resident of flat number 509, Designers Park, Sector 62, Noida, Gautam Buddha Nagar, UP is our defendant. So name parties will remain same, please note. Then center heading will be application for review of judgment dated 1st November 2017 and to set aside the consequent decree under Order 47, Rule 1 of CPC. What is your center heading? That you are filing an application for review of judgment dated 1st November 2017. And after the judgment, decree is also prepared. So you want that judgment as well as consequential decree should be set aside under Order 47, Rule 1 CPC. And you will begin your drafting like this. The applicant plaintiff most respectfully submits everything. You are applicant in this application, in this review petition, and you were plaintiff in the original suit. That means some order has been passed against plaintiff. Para 1. That this Honorable Court was pleased to dismiss the suit of plaintiff for specific performance on 1st November 2017. The suit of the plaintiff for specific performance of the contract was dismissed by the trial court on 1st November 2017. All right. Para 2. That no appeal has been preferred against the decree and judgment delivered by this Honorable Court. You have a right of filing appeal, but you are not going in appeal. You want review by the same court. Yes, this is your legal right. This is allowed. Para 3. In the judgment of this Honorable Court, there is apparent error on the face of record, as this Honorable Court has omitted to take note of the following. What ground you are taking? That there is an error apparent on the face of the record. What lower court has omitted? Para 4. That this Honorable Court has dismissed the suit of the plaintiff for specific performance of the contract on the ground that no such agreement dated 1/1/2017 was proved between the parties to the suit because the plaintiff failed to file the original agreement. It is submitted that original agreement was stolen from the house of the plaintiff on 10th January 2017, whose FIR was lodged by the plaintiff at the police station sector 128 Noida. Once the original agreement is stolen from my house, how can I produce it in the court? I cannot. Para 5. That during course of investigation, the IO has recovered the said agreement from possession of one of the accused. It is my good luck that original agreement dated 1/1/2017 has been recovered by the police. And plaintiff has got it released from the court of CJM Noida on 17th November 2017. After passing of the judgment, I got the possession of original agreement. I got it released from the criminal court. And the same is being filed along with this application. At the time of filing the suit, I was not in possession of original agreement because it was stolen. After the judgment, now since the IO has recovered the original agreement from the possession of the accused and I got it released from the criminal court, now I am filing the original agreement before the trial court along with my review application. Para 6. That the plaintiff had filed a certified copy of the said agreement after taking it from office of sub-registrar where it was registered. But Honorable Court failed to appreciate the legal position of filing secondary evidence in accordance with Section 65 and 66 of Indian Evidence Act. Since the original was stolen, original agreement was registered in the office of Sub-Registrar Noida. I had obtained certified copy from the office of Sub-Registrar Noida, and this is my legal right to file secondary evidence when the original is lost in view of Section 65 and 66 of Indian Evidence Act. But the lower court has not believed my story. They have not believed my secondary evidence. They have not believed the certified copy issued by Office of Sub-Registrar Noida. Para 7. The Honorable Court failed to appreciate the ratio decidendi of case laws decided by the Supreme Court, which was submitted on behalf of the plaintiff. I submitted so many rulings that when original document is lost or destroyed, I have a right to file secondary evidence. But the lower court failed to appreciate the ratio decidendi of all such cases. Now the prayer is, it is therefore most respectfully prayed that this honorable court may be pleased to review the decision given in this suit on 1st November 2017 and set aside the decree passed in the suit and rehear and decide the case. You want that your matter should be reviewed, it should be reheard, and a fresh decision should be passed. Then you are supposed to mention the place where you have made this drafting. Say places, Noida, and then date also. Dated 20th November 2017. Plaintiff has to append his signature on this review petition. So you will obtain the signature of your client. And since this review application has been drafted by some advocate, ABC advocate, you will write down through counsel, ABC advocate, and ABC advocate will also sign this review application. Then, dear students, lastly, review petition has to be verified like a plate. So, center heading verification. I, A, the plaintiff appellant, do hereby verify that the contents of this review petition from paragraph 1 to 7 are true and correct to my knowledge. And after verification, again, the signatures of applicant oblique plaintiff are required. And since this review petition has been drafted by advocate, so his name will also appear that you are filing this petition through ABC advocate, and ABC advocate will also put the signatures. Again dated, date of filing this review you are supposed to write down, that is 20th November 2017. The time limit for filing review application under Indian Limitation Act is 30 days. So you are filing this review in 30 days. So dear students, this is how we have learned the grounds of review petition as well as drafting of a review petition, in which we have drafted the grounds of revision also. So thank you very much, dear students. God bless you all.